So welcome everyone. Just a quick recap on who Goodwille are in case you're not familiar with us. We have helped over 2,000 businesses for more than 25 years to establish, grow or scale in the UK. Our core offerings are governance, finance, payroll, virtual office, and of course, HR. Here today we have Helen and myself from the HR team. Again, if you're not familiar with us, I look after the HR department at Goodwille, and Helen is a senior advisor within the team. Our HR team can help you with any employee-related matters that you might have, so from hiring to exit and everywhere in between. So any employee relation issues, contractual matters, the list is pretty extensive. And we can also help you on the global mobility front as well and with training. So do reach out to us if you have any other requirements. But what we're here for today, so of course, as Nancy mentioned, this is a follow-up to the briefing that we had back in July. So of course, we held a webinar post the election of our Labour government, and some of you may have attended that, where we were informing you of the pledges made by Labour as part of their election campaign. And their promise to turn the desired legal changes around within a very ambitious 100-day period. So that, of course, sent shockwaves through panic and terror and all of those things throughout the HR and legal community. So we did say that we'd follow up. Today, we're going to be telling you about the next steps to the government plan on Make Work Pay. And also the changes in protective legislations on sexual harassment in the workplace, which actually comes into action later this week on the 26th of October. On the 10th of October, the government introduced the Employment Rights Bill. So that's the first phase of the plan to make work pay. And many of the commitments in Labour's Make Work Pay manifesto have now been fleshed out in this draft piece of legislation. But while quite a few of the changes will come into force immediately once the bill has passed, that does still require further consultation. And so many of the proposals did not appear in this first draft of the bill. The abolition of the qualifying period for unfair dismissal, so that becoming a day one right, which everyone got hugely excited about, that hasn't appeared in the bill, but note that this is set for autumn 26. So we will be talking about probation periods today. But yeah, let's kick off with some changes happening in the next few days. So I'll hand off to Helen to talk about the harassment piece.
Thanks, Jackie. So first off, I wanted to talk about the changes in sexual harassment protections in the workplace. And this is something that we know is going to happen. It's going to change at the end of this week, as Jackie said, on the 26th of October. So this is definitely happening and definitely changing in terms of the protections that are going to come into play and the things that you and the companies that you work within need to be thinking about. So it looks at the requirements for employers to put implementations of protective measures to protect employees in the workplace. So it's really important that you have a look at your workforce and conduct risk assessments in terms of what the risks are and the likelihood of sexual harassment occurring between employees and customers and suppliers. And then the next step is to look at what reasonable steps the company can take. So it's really important to have a look at those various different factors. Every company is different, so it's not a blanket approach across everyone needs to do a certain set of things. It's very specific in looking at what the risks are for your company and what reasonable steps that you can take. So what we're recommending our clients look at are a number of things. So that's firstly, have you got any policies in place already and do you need them? And that your contracts are reviewed in terms of some things referring to specifically about sexual harassment. So first off, I want to talk about policies and handbooks. So things to think about here are they available to all? Are they easily accessible to everyone? And they need to be. They shouldn't be held on someone's OneDrive or someone's computer where no one else has access to them. They need to be available and freely available for all. They also need to be reviewed. So it's not a protection or something that you can rely on as a defence to say, well, we have this policy, but it might be 5 years out of date. You need to be reviewing it regularly, and you also need to be circulating it. So making it, again, available for everyone within the workplace. The other thing to think about is it a global policy or is it UK specific? There are certain things in the UK that are different to other companies across the world. And as I mentioned, having a look at your contracts. So does it specifically mention that harassment and sexual harassment would be considered gross misconduct? And is that identified within your handbooks and policies as well? Some other things that you need to think about is training. So it's really important that employees are talked to and that there is training in place for to identify sexual harassment and what to do in those particular instances, but also linking that with bullying and the wider harassment piece as well. And things to think about that are, again, very specific to your company. So is that going to be training in person? Is that going to be online? Are all new starters going to be put through the training? But really important to think that it's not just a one-off. So it shouldn't be just an induction only, or when someone starts within their first month, as an example. It needs to be updated and revised and reviewed, and it needs to be delivered on a regular basis. Again, it wouldn't be a protection to say, oh, a new starter has had some training, but they started with the company 3 years ago. It needs to be regularly reviewed and regularly delivered as well. You might want to think about having a separate and single sexual harassment policy, again, depending on what your risks are as the company. And although it's not in place right now, the changes that are going to be coming, and that's something that Labour are really keen on introducing, is looking at third-party liabilities. So you should start thinking about now putting liability clauses in third-party contracts. So that might be if you're working with clients and customers, having a look at those contracts that you have with those people to ensure that you're covered for third-party liability in relation to sexual harassment. As I mentioned, it's not going to come into play this week, but it's definitely something that will come into play over the next few years. So it's important you start taking a look now. So just looking at moving forward and what other things that Labour are going to enhance on this side of things. I've already mentioned third-party harassment, but they're also looking at changing the wording in terms of reasonable steps and putting back all reasonable steps. So it's really important that you take into consideration the changes in the legislation that are happening this week, but also looking at what all reasonable steps that your company can make to protect both your employees and the business. It's going to be a general theme throughout some of the things that we talk about here. They've suggested that all reasonable steps are going to be coming into play, but they haven't given us any specific guidelines in terms of what that would mean in practice and reality. But as soon as we know anything more on that side of things, then we'll release some more information on that. And I'll hand over to Jackie on the next piece.
Thanks, Helen. So I did briefly mention on the introduction about the day one unfair dismissal rights not actually being specifically covered or fleshed out in the bill, other than we are going to expect the changes to come in autumn 2026. But just as a reminder, so the current legal position that we have in the UK is that for employees with less than 2 years of service cannot make a legal claim towards their employer for ordinary unfair dismissal if they terminated. So long as there's no breach of contract, then currently any exits for employees with less than 2 years of service, they hold very little risk of legal action unless there can be a claim made for automatic unfair dismissal. So that means where there's any allegations of discrimination, as an example, or harassment of any sort, not just sexual harassment, whistleblowing or asserting statutory rights or trade union activities. So it's quite lean at the moment in terms of risk levels, where there are periods of less than 2 years of service when it comes to termination. But the new legislation will mean that this qualifying period of 2 years will be abolished, and that employees will be protected from ordinary unfair dismissal from day one of service. So again, not coming in for a little while to be written into our actual legislation, but we do know, and what's being consulted on at the moment, is that there will be a statutory probationary period introduced. So that will be mandated for every company to offer at least this minimum period of probation. And during that time, there is going to be a light touch process for employers to follow in order to be able to dismiss an employee fairly. So we do expect that this process will be some modified, watered down ACAS process, but it is likely to involve a formal meeting procedure with evidence required to justify the decision to dismiss. And it is likely that there will be a statutory right to be accompanied within that as well. We don't at this point know if there will be a right to appeal. In terms of the consultation that's happening at the moment, I mentioned there will be a statutory duration for probation period. The preference is currently being held at 9 months, but that may change. There will also likely be a change to the compensation regime available to claimants if their claim for unfair dismissal is upheld during their probation period. But again, it's not likely to come in before autumn 2026. We do, however, need to think of the future impact on your businesses, though, and what you can be doing now. So, of course, when this does pass, the impact is likely to be quite significant on companies. We do expect that there's likely to be a rise in cases heading to tribunal on the grounds of ordinary unfair dismissal. And maybe we might see a reduction in cases of automatic unfair dismissal, as in, employees trying to angle their claim towards a discrimination angle. There will be a greater need to invest in training of your managers to monitor performance and conduct better. So they will really need to be clear on how to follow fair procedures, which are compliant with the new legislation, and really know when to involve HR. So we suggest this should be at an early stage. We also recommend that you start looking at your recruitment and probation processes now. So get ahead of those changes, make sure that your operating processes and mechanics are embedded into the business now, and that you have the time to educate your managers and they know exactly what to do by the time these changes come into play. So when we think about recruitment, think about how thorough your vetting process is. Are you using behavioural and cognitive assessments? Do you ask the right competency-based questions at interview? Is there a consistency to your process? How many stages of interview are you holding, and who are you getting involved in that vetting process? Are you doing referencing as part of a conditional offer before you have a start date? So all of those things are going to be really important to consider. But when it actually comes to the probation process, think about how you're monitoring performance and how you support your employees through probation as well, because that's going to be an important factor as well as to whether an exit is fair. Like, what support has the employee had to perform during that probation period? You'll really need to make sure that you're documenting your probation processes properly and that they're tracked, and you have evidence on file in the event that you do make a decision to exit. It's also been proposed that some companies may resort to hiring contractors or use a temp to perm route via agency to trial whether someone is a good fit for their business. So kind of bypassing this initial 9-month period, which they would still need to then apply once someone comes on board as a direct hire. So that is something to think about. Maybe not the best move, but something to think about once it comes in. But yeah, I mean, ultimately, we do think that from our understanding, it is really likely that if you are going to dismiss, you are going to have to go through a light touch process, but there will be a process as the main take home. So do reach out to Helen and I if you want to get some further information or further help on that, because, there's autumn 26 is a while away, but to actually put processes in place and to prepare, it's really not that long. I'll pass on to Helen now.
Thanks, Jackie. I'm going to speak about sick pay next. So the current arrangements in place are that statutory sick pay is paid at £116.75 per week, but there's a waiting period of 3 days of absence. So it's not automatically paid from day one currently. And also there is a limit, so you have to earn at least £123 on average per week before you become eligible for statutory sick pay. So the government are proposing new rules will be in place, and that payment would be due from the first day of absence rather than the fourth day of absence. So they're removing the 3 waiting days. And also they are going to be looking at removing the lower earnings limit. So everyone who is an employee from day one will have some entitlement to statutory sick pay. That being said, they are going to consult around the levels of sick pay for those who have lower earnings, and that might be a percentage. But again, at the moment, we don't have the confirmed details of what that might look like. But there are periods of consultation to look at what that might be, and that will be fleshed out as we go forward. As with a lot of these things, we don't have a set date of when they are definitely coming in place, but it's definitely something to have on your radar, in that statutory sick pay will be eligible. You would have to pay from day one, and you might want to have a look at, enhancements, and if you don't already have those in place, what company enhanced sick pay that you might want to put into place. Next slide, please. Another key thing to think about is the national minimum wage. So at the moment, there's a tiered approach to the national minimum wage, depending on how old someone is. And the government has committed to progress plans to having a flat rate for all adults. So that's for everyone over the age of 18, there will be one flat rate. And therefore removing the discriminatory age bands that we currently have in place. Excuse me. So in addition to this, they're also looking at reviewing the levels of the national minimum wage to take into account the cost of living increases that we've experienced in the UK over the most recent years. Again, there's nothing set in stone in terms of when this will happen, but what usually happens in terms of national minimum wage changes are that they are implemented each April. So there may or may not be something coming for April next year. Again, we don't have a definite set date, but if something's going to happen, it may well be April next year. And I'll pass back to Jackie.
Thanks, Helen. So we also have some changes coming to family-friendly rights. As of today, at day one of employment, there is no right to bereavement leave or paid paternity leave or unpaid parental leave. So the changes will mean that paternity leave will become a day one right instead of the current 26-week rule that we have. We do expect there will be a statutory rate for payment, but that hasn't been disclosed as of yet. Unpaid parental leave, so that is non-birth or adoption related parental leave. It's available for parents to spend time with their children up to the age of 18 years old. Currently, the qualifying service period for this is 1 year. But this will become a day one right, but we do expect that this will remain as an unpaid leave payment or non-payment. Protection from dismissal will be strengthened for pregnant women and new mothers, as well as those returning from family-related leave. So the current protections that we have in place, they apply in the event of redundancy. And that includes the right to be offered suitable alternative employment and given priority to that. But it's expected that this may be extended through future regulations to apply to other types of dismissal taking place after a protected period. So that will be broadly a period of 6 months after that maternity leave has ended. But again, we don't have the particulars on this yet. The government has also committed to review carers' leave. So that is introducing the possible introduction of paid carers' leave. So we did have a change not so long ago that did introduce the right to take 1 week per 12-month period of carers' leave, but that is actually unpaid. So this is actually introducing a statutory rate of payment for that. But again, we don't have the particulars on that at this time. Next slide, please. One before. Thanks. And then we also have changes coming for bereavement leave. So currently there is no right to a minimum period of time off for non-child family bereavements, or the right to payment during this time, other than for statutory parental bereavement leave. So the law is quite fluffy on non-child bereavement. It basically says that you need to give reasonable time off as an employer, which is extremely vague. Of course, companies can choose to have their own policy, which details the time off that they grant under their company policy and the payment linked to that, and also the family relationships covered under that. But from a statutory angle, there is no legal right to payment or a prescribed set time off, so it's very open. So the government are looking to broaden the right to this leave in terms of family bereavement, so that the payment and time off is not confined to bereaved parents, and it will also become a day one right. And the regulations will also set out the relationship to the deceased covered under this new regulation and the payment that it might allow. So we think it might be 1 or 2 weeks of statutory bereavement pay, but we don't have confirmation at this time of what that will be. But do think about that in terms of the policies you might want to put in place, as with everything else we've been speaking about today.
I'm going to talk about flexible working. So we had a recent change in employment law in the UK that made the right to have and request flexible working from day one of employment. That's recently changed earlier this year. So the right to request it is already in place, and the right to request that from day one is already in place. However, the Labour government are looking to strengthen these arrangements. So they are looking to implement that employers will need to show that there is a reasonable reason to refuse a request. And there's 8 existing grounds that you can refuse a request currently, and there's no indication that they will change. And some examples of those might be that there will be an extra burden of additional costs to the business, or it would mean that there's an inability to meet customer demands. They would be valid reasons to decline a flexible working request currently. But what the government is looking to introduce is an extra step to this, and that companies would need to explain and need, as part of the refusal, to state the grounds that it's being refused and explain why they consider that it's a reasonable point to put across to refuse the application. So that part is new and that will come into legislation. We generally advise, when you're looking at flexible working requests, that you should explain the reason anyway to employees, but this is putting in UK law that you must state the grounds that you're refusing and that you explain why. There will be some consultation around this. Again, they've not specified a time frame of when these new changes are going to be put into place, but when the consultation finishes, it's likely to be a very swift or immediate change that things will come into play. To give you some idea about what the penalties are if you don't apply, what rules are currently in place and the new rules going forward. So the penalty would be, for failure to follow a fair process, would be 8 weeks pay, and that's capped at £700 per week, and that penalty isn't due to change. I also wanted to talk about some things that are happening in the UK press at the moment. There's been lots of talk around compressed hours and 4-day working week, and that would be a 4-day working week but at full pay. So it was trialled across various different businesses, and there's another trial that they're looking to put forward in November this year. So there may be some more pressure to the government, and there may be more information coming through the press around these arrangements. But as I mentioned, the law currently stands that employees have a day one right to request flexible working. So what you should need to do going forward and from now on is to be really mindful about these changes that are happening, and consider flexible working requests as and when they come in, and feel free to reach out to Jackie and I if you need any support on those. Next slide, please. I also wanted to talk about 0-hour contracts. So the government is looking at the arrangements for 0-hour contracts and are going to introduce some significant changes in this area. So they're looking to provide guaranteed hours, which reflect the average hours that have worked over a 12-week reference period. They're also looking to introduce reasonable notice that should be given for any shift changes. And they're looking to introduce a compensation that should be provided to workers where shifts are cancelled or curtailed. So that's a really big change in terms of the arrangements that we currently have in place for 0-hour contracts. It's important to note that workers can request to stay on 0-hour contracts if they want to, but that must be a request from the worker. So that might be for students who enjoy the flexibility of 0-hour contracts. But as I mentioned, it's really important that that request comes from the worker and it's not imposed by the company. So sorts of things that will have an impact for companies that use 0-hour contracts. So it will impact on your work forecasting. You'd need to have a look at a 12-week reference period and then future plan based on that as well. There might be an increase in baseline costs for you. You might have less flexibility in terms of what hours that you can offer to your workers. There would be an increased risk of claims because you would have to then provide hours on a 12-week period and look at reasonable notice and possible compensation for changing in working patterns. You might decide to increase your agency use. If you've got particular seasonal demands, there'll be that will be impacted directly by the 12-week reference period. And we might see a extension to some statutory and parental leave rights coming forward for workers under 0-hour contracts. So there's lots of changes that are laid out in the new bill for 0 hours. However, they haven't given a lot of specifics and a lot of detail around this. So they are out for consultation on this piece at the moment. And as with lots of these other things, we are needing to wait for the detail to come out in terms of exactly what this means. But what we're looking at right now and what companies can do right now in order to look at this piece is to really understand your current workforce. So look at those who are on 0-hour contracts and look at, are they working regular hours or is it really sporadic and truly a 0-hour contract? And have a look at 12-week reference periods in terms of how many hours people are working over that point in time. If people are working regular hours and consistently working regular hours, you might want to look at fixed-term contracts or moving them onto other contractual arrangements. And as I mentioned, you might want to look at some more agency use. And you really need to look at your plans. So what plans for hours worked are you going to need? What recruitment plans do you have? And looking at whether 0-hour contracts are right for that, or whether it's some other contractual arrangements that you need in place going forward. And I'll hand back to Jackie about the next piece.
Thanks, Helen. So we have fire and rehire, which is very controversial in the first instance. For those of you who don't know what that is, this is where an employer needs to make contractual changes to an employee's terms and conditions. To do so, that does require consultation and agreement with the employee or the pool of employees involved. In exceptional circumstances where there are genuine and pressing business needs and agreement can't be reached, employers can sometimes be, in their view, justified, and they will, change workers' terms and conditions by terminating their contracts and rehiring them on new T's and C's. Now, the government don't like this. They see this as being a loophole in the law, and they have stated that they're going to end fire and rehire. So the suggested reform will include introducing a new ground of automatic unfair dismissal. So that's again in line with being, claiming discrimination and harassment and so on. So that's generally what automatic unfair dismissal means, for which unlimited compensation can be awarded if the claim is upheld at court. So yeah, not good news for companies that would be resorting to fire and rehire situation. Companies may be able to avoid liability if they can show the reason for the contractual variation was to reduce financial difficulties and that they really had no other choice. But the test is likely to only consider really extreme cases, such as the company is going to be going bankrupt if they couldn't implement the changes. So we feel that, this is going to be very unusual and only used in very limited circumstances to not fall foul of the law and to end up with that unlimited comp. So yeah. Then next slide, please. And then we have the collective redundancy period. So the current position is that where there are fewer than 20 roles at risk of redundancy at what we call a single establishment, then a redundancy process can be carried out on a small scale basis. So that means that there's no need to run a redundancy process as a collective consultation, which if you do need to, lasts a minimum of 30 or 45 days, depending on the volume of the roles at risk. There's also a necessity to appoint employee representatives. So it's a lot more rigid in terms of process, but small scale processes are not as rigid, and they can be completed in a much smaller time frame. There's a lot of case law out there in terms of what is considered a single establishment, but generally an establishment is the unit or workplace to which an employee is assigned. It doesn't need to have its own independent management or be administratively or financially separate to the rest of the business, but it would be expected to have facilities and a workforce and an organizational structure to enable it to perform specific tasks as a unit. So you would need to obviously deem what if you have a single establishment as it is anyway, as per the law today. But the bill is removing the single establishment rule or requirement from collective redundancy consultation obligations. So that will mean moving forward, once this is passed, that where you are making 20 or more proposed redundancies within 90 days across a whole business, even at different sites, then it will trigger the collective consultation requirements. So that does mean that generally speaking, one rule will be if you're making 20 or more redundancies, then you will need to go through a collective consultation, and we are looking at the prescriptive 30 to 45 days as a minimum period for consultation. Next slide, please.
I'm going to talk about trade unions. So the new bill and the proposals will also require employers to give workers a written statement advising them that they have a right to join a trade union. So currently that's not legislation, so this is a new piece of work that's coming into play. So trade union recognition will be made easier, and trade unions would also be provided with the right of access to the workplace through these agreements. So this means that once the bill is passed and this becomes law within the UK, you'll need to update your contracts, your written statements that you give to new starters to make sure that this specific clause is included in there, and that handbooks and any other policies related to trade unions will also need to be amended to confirm and reflect the new legislation. It's also important to understand that there will be the right to access workplaces for trade unions, and again, that's not currently in UK law. And as I've mentioned and Jackie's mentioned, as with a lot of these changes, we don't have a set time frame of when this is going to take place. They're at consultation at the moment. So we'll just have to watch this space on when this becomes law, and that you need to have them in your contracts and handbooks going forward. Next slide, please. And next, I wanted to talk about the Fair Work Agency. So the government have committed to establish a new enforcement agency, the Fair Work Agency, which will bring together under one roof existing enforcement powers and also reinforce the relevant labour market legislation that's in place. So this will look at things like whether companies are applying and making the right payments in terms of statutory sick pay and national minimum wage. They'll also be able to check on general record keeping obligations within businesses, and also check that the relevant holiday pay is being calculated and paid or taken by employees. And it's really significant that the agency will have powers to actually enter employers' premises and inspect documents. So you need to start thinking now in terms of what record keeping that you have and making sure that that you're meeting all of these requirements. Obviously, Jackie and I make sure that you do in terms of the payments that you're making for statutory sick pay along with payroll, and that we advise you on those points as well. But it's important to note that this agency will have powers to go into employers and companies' premises and have a look at those documents, and that's a really big change. Again, as with lots of the other things, we don't have a time frame in place for this, and it's currently being consulted upon.
Thanks, Helen. So we have pay gap reporting, which has been around for a while now. So the current regime on gender pay gap reporting is that it's necessary for companies with more than 250 employees to publish their data on salaries and the pay gaps between gender groups. So just for your information, the current gap is 9% generally to the favour of men. But currently, there are minimal powers to take action against employers or penalties when an employer is not compliant, other than, of course, reputational damage, but not much more. So the government are looking to change this, and there are plans to make it mandatory for employers to provide a narrative on why there is a gender pay gap, and also a commitment to remedy this within a set period of time. Again, we don't know what that will look like. There will also be a new provision to extend this requirement to include outsourced workers. So that will be interesting if businesses have visibility to the outsourced workers' salaries anyway, if they're using consultants as an example. The bill will also provide for regulations to introduce a requirement for large employers to produce equality action plans on how to address their gender pay gap. And also there will be a requirement for supporting employees through the menopause. Any plans to extend the gap reporting? There's also plans to extend this gap reporting to cover race and disability. But the thought there is, we're not quite sure how that will be done. If we think about race as an example, there are so many variables and categories when you're collating your EDI data. How can an organization categorize race in a smaller workforce if you have just over 250 people as an example, and produce data that's actually meaningful? So that's something that we're going to get some more information on once there's further consultation. But for now, you might want to think about how you're obtaining your EDI information from your staff. So again, obviously we have the gender part, but if you are thinking about how you collate your race and nationality data, your disability data, how do you get that, and when do you gather that data so that you have that for your files? Next slide, please. And then we have the immigration piece. So this may be something that you are aware of, maybe not, but Helen and I thought it was important to include. From 2025, everyone, including children who are not a British or Irish passport holder, or who are living in the British Overseas Territories, which is normally considered Ireland or whatnot, they will need to apply for permission to travel to the UK in advance of their arrival. So this will be either through an ETA or an e-visa. So ETA means electronic travel authorization. So ETAs are digitally linked to a traveller's passport, and they will allow security checks to be carried out before the traveller begins their journey to the UK. And so this means that there will be changes to the standard visas. So this means that people who are traveling for leisure or people that are coming on short-term business trips for activities permitted under that route. So not a working visa, to be clear, not employees who you are sponsoring. This is for business visitors. So the ETA is like the US ESTA. It's being rolled out in 3 stages. So there are a set list of countries where this ETA is being rolled out in phased stages. And it basically means that there will be a requirement for individuals to apply for this ETA to gain permission to enter the UK. Again, with the same restrictions under the standard business visitor working rules, but effectively automating everything. The cost will be £10. It will be linked to the duration of someone's passport. So the permission to enter the UK will last for 2 years unless the applicant's passport expires sooner than that 2-year period, in which case the ETA will also expire. And it will be a requirement to apply at least 3 working days pre-travel, because the turnaround is expected to be around a 3-day period. And the scheme is already live for countries in the Middle East, with the exception of Jordan. From the 27th of November, eligible non-Europeans, so including people coming from the US, if we have anyone with colleagues or on this webinar from there, or Canada or Australia, can apply online for an ETA from the 27th of November. And they will need that ETA to travel to the UK from the 8th of January. And then from the 5th of March 25, the ETA scheme will then be open for eligible Europeans, and that will be required for travel from the 2nd of April of next year. So I guess that will account for the majority of our attendees who have colleagues or they themselves may be living in a European country. And I think that's the end of our session. We do have a roundup, of course, but all of the pieces where we've spoken about, that's enough education for the morning. As Helen, do you have any thoughts on what you think could be take-homes for everyone on the call today, of what you can be doing now?
Yeah, I think definitely around sexual harassment, we know that the law is changing at the end of this week. So if you haven't already done anything to consider the changes and what it means to your business, then it's really important that you do that sooner rather than later. And just to recap on that, so it's looking at doing a risk assessment for your business. So in terms of what the risks are and what's reasonable for you to implement to mitigate those risks. So that might be some training, whether that's in person or online, and making sure that those things happen on a regular basis. So it's not just a one-off, but also looking at any policies or handbooks that you might have in place and making sure that they've been updated, reviewed, and circulated recently and are available for everyone at any point to access.
Yeah. And I guess on the day one rights for unfair dismissal, again, they won't actually form part of legislation until autumn 26. So we do still have that 2-year period. Obviously, that doesn't cover automatic unfair dismissal, but we do strongly recommend that you start getting your processes in place now. Get your managers trained on what is a suitable probation process, what's a fair probation process, what support you have in place, and really get your recruitment processes sorted out now so that you're ahead of it, and you're hopefully going to be needing to make less terminations in the short term anyway. So yeah, of course, Helen and I are happy to help you with that. If you should need a steer in the right direction, or if you need to develop some plans, then we're here to help. And of course, do bear in mind my comments on the immigration piece, because of course we don't want your colleagues overseas getting stopped at border control when they try to enter the UK next year. So do please bear in mind that there will need some forward planning for any meetings that they may need to attend in the UK.